Good afternoon, everyone. Today's webinar is on the topic Common Legal Mistakes a Startup Makes. The speaker with us is Mr. Anirudh Rastogi, who is a founding partner at Tanikella Rastogi Associates, and he specializes in representing startups. He's also an alum of Harvard Law School. He's qualified practitioner in US and India, and he's also a book. He's also author on the book of cyber law. So yeah, hi Anirudh.
Hi Garima, thanks for the introduction, and I'll take over now. Hi everyone, thanks for taking out the time and joining us. I'm going to be talking today about 10 common legal mistakes that startups make, and we often get the question from when we're talking to startups or promoters. I'm sorry, just wait for this disturbance to get through. Yeah, so often when advising startups and promoters, we get the question on what is the right time in the stage of the company to start thinking about legal issues. And while the answer is not, so there was is there some disturbance?
Yeah, now it's better. This is the phone ringing, so I switched it off.
All right. Okay, thanks. Yeah. Right. And the answer to that is not, it cannot be set out in stone. Basically, I will read out a list of certain issues that I'm going to talk about today. But there are certain issues which, of course, a promoter can prioritize and start thinking about from day one. But there are certain others which could be deferred to much later. And definitely, certain issues can be taken up in month 4 or month 6 of activity or post funding. But I will talk through various issues which at least promoters should keep at the back of their mind, and how to prioritize them. So quickly go through a list that I've made for myself on certain key issues which promoters should keep in mind. First being not making the deal clear with your co-founders or not entering into an agreement with co-founders. Second is not starting the business as a company. Third would be not evaluating regulatory issues relating to your business. Fourth, coming up with a name for the company which has a trademark issue or a domain name issue. And fifth, related point, not carefully considering your IP protection. The next point is giving away too much in your angel round term sheets, not having a good terms of use and privacy policy for your website, not having great standard form contracts, and not taking into account important tax issues for your business. And the last self-serving point, not having the right legal counsel. So I will go through each of these points one by one and kind of give you a little perspective, both from a legal as well as a commercial standpoint, in how to prioritize these issues in terms of their importance. So the first one is not making the deal clear with co-founders. Whenever you're starting a business with co-founders, it is absolutely essential to have your interstate terms set out on paper. A lot of co-founders defer that decision to much later until they are literally compelled to enter into a co-founders agreement. And the reason is usually one and this is also a question that I face a lot of times, or a concern that promoters come to us with, saying that co-founders, it's just a difficult conversation to have in terms of how the equity should be split, which is of course a more basic question, and usually most promoters, more often than not, will actually answer that before setting out together. But then, how is the equity going to vest amongst you? Are there going to be other rights and obligations or roles that each of the co-founders are going to perform, and whatever terms they're going to have vis-a-vis each other? Yes, it does become a difficult conversation, particularly when you're co-founding with the company with close friends or people you've known for a while. But the ability to have this conversation early on, one, reflects on the maturity of the team, which ideally the team should have if they are to start out doing business together. Second is, it is much better having that conversation, that difficult conversation, early on in the business than much later, say 6 months down when you're starting out the business, because these questions are bound to crop up any which way. Some of the key decisions that the co-founders have to take when setting out or putting in place a co-founders agreement I can give you various examples of things that of stories both from popular media, which are deals which have been reported very widely, or from my own experience dealing with clients, of the kind of implications of not having a clear co-founders agreement. Of course, everybody's seen the movie Social Network, and the kind of now fairly well-known dispute story of Mark Zuckerberg and Eduardo Saverin, where Mark was literally able to dilute his co-founder's stake down to or close to nothing without his consent. That was a result primarily of two friends coming together, not sitting down to set out the deal terms on paper when they're starting out the business. But also, I mean, examples from my own deals that I've worked on, or clients I've advised. Something funny as it may sound, but it's a great story to share, and I think the conversation can leak from there. A business that I've been representing for a while, started by two friends, was doing fairly well until last year, until which one of the co-founders decided to kind of travel to Europe on a vacation, never to return back, literally. And he moved on. He chose to move on in life. But what happens as a result is that he's still sitting on 50% equity in the company, and there is really not much that the other co-founder could do about it. Now, this is just one example, but it is a very it is definitely a possibility that stares at us in the face. The point is, co-founders over a period of time, or different people over a period of time, are bound to have different priorities in life, or either they want to move out, exit, or deprioritize, or take up other priorities, take up another job, or start out something else on the side. How do you ensure that the equity allocation then is adjusted upon the exit of the co-founder, or upon his taking up some other project, or not giving his 100% into the business? The way we do that is by coming up with what is called as a vesting structure, which typically means that if supposedly the two co-founders who are entitled to 50% equity in the business, that equity is not given to them upfront. And instead, it is given to them over a period of time. Say, for example, if we choose a 3-year vesting period, the 50% equity will be given to them over the three-year period. For the first year, they do not get anything. And of course, these are all terms which can be negotiated based on the unique circumstances that the co-founders find themselves in. But it's a very typical clause that first year you do not get anything, because it takes that much time, or the co-founders at least have to agree to commit themselves for a minimum period of 1 year. Post which the next 2 years they will get their remaining equity on a monthly basis, on a prorated monthly basis. So this only ensures that if supposedly a co-founder were to leave in month 6, much before the first year, he leaves the business at his own peril, he doesn't get any equity. If he leaves after year 2, then he gets only equity in proportion to the time he spent with the business, not anymore. Similarly, what happens if he's leaving the company on his own volition, as opposed to where he leaves the company, or he's compelled to leave the company because of some kind of some misconduct on his part. So different kinds of scenarios, we can provide different kinds of equity allocation. But it's a very important term, because this is the reality of life in a startup. Co-founders do, not all co-founders kind of go through and work together through the life of the company. So this is just one very important term, but then there are other terms which should find themselves in a co-founders agreement. Confidentiality clauses, non-compete, that you will not enter into any business during the life of while you are with the company, and even after, for a certain period of time, you will not enter into a competing business, or you'll not be employed with, nor will you advise, nor will you be an investor in a competing business, because you have access to fairly confidential information. You know the business inside out. You know how we work. So that's another fairly important clause. The roles of the co-founders need to be set out with clarity. You need to have a list of reserve matters, as we call it, which is a list of certain key decisions regarding a business, which cannot be taken without the unanimous approval of all the co-founders. These are terms like changing the very direction or changing the very nature of business that the company performs, for example, or starting a subsidiary of the company, issuing more equity stake in the company, which could potentially dilute all the co-founders. These are important terms which no one or not even a majority of the co-founders should ideally be able to take. Every single co-founder should have a say in these in deciding these terms. So these are fairly important terms. And of the list of certain matters that I listed out when I started talking to you, I think there's one thing that you as a promoter need to keep in mind when you're starting out. And that one thing has to be a good, fundamentally strong co-founders agreement, because many startups, in my experience, fail primarily because of co-founder disputes, and that can very well be addressed by having a good agreement in place. Given that you will probably never want to litigate an agreement, even if something were to go wrong, but the sheer fact that you have a well-stated document governing terms vis-a-vis yourselves, it's just a document which keeps people from resorting to disputes, which keeps kind of from any ambiguities cropping in, because everything is set out on paper. And people often, even if there is a dispute, often just go back to the document. It serves as a document which kind of guides you on various eventualities, and you're able to act accordingly. Keeps people from going to the court, basically. The second important point or issue that the co-founders often ask us about is whether they should start the business as a company or not, and if so, at what stage. And the reason this question crops up is because incorporating a company is definitely a time-consuming task. It also is a cost. And typically promoters are in a hurry to start out and hit the road running with the business. This is one thing where one issue where one general point I would like to make is that as of today, a company is definitely a better or the best available entity structure for starting a new business, as opposed to, say, a partnership firm or a proprietorship firm. And the reason for that is particularly from an investment perspective, which is that investors are most comfortable, or almost all investors are comfortable investing into a company structure, not into a partnership structure, not in a proprietorship structure. The reason is that in the Companies Act in India does provide for a very strong corporate governance mechanism, which is that there are a number of obligations on shareholders and directors on the company to keep from certain activities which could otherwise be to the detriment of other minority shareholders, for example, or the company in general. So from an investment perspective, if you have to raise an investment, a company is the ideal entity structure. Having said that, and acknowledging the fact that it takes time to incorporate a company, it does involve a cost. You can certainly defer the decision to incorporate a company for a little while until you are sure you want to really go ahead with the business. A lot of people get together, start a business, try it out, and only to decide that, well, this is not a business they would want to continue with. And a lot of businesses do kind of fall through at that very early stage. So you could wait until you have clarity that you want to really go ahead. But one thing you need to keep in mind is that you will require a company before you start when you start hitting investors, or when you have some investor interest, because investors will only put in money into a company structure. And there are many startups which start this process, the incorporation process, when the investment term sheet is already kind of underway, which then of course delays the entire investment process. The third issue I would like to talk about is evaluating regulatory issues relating to your business before you start out. Now, this issue takes importance for some startups more than others, If you are going to operate in a highly regulated industry, then of course you need to have clarity on the kind of regulatory issues that you're going to face. I mean, there are certain models where you cannot even start, where we can't even operate without having certain specific approvals or licenses in place. A couple of very heavily regulated industries could be anything to do with pharmaceuticals, for example. There has been a lot of interest in e-commerce of or online sale of pharmaceuticals, a regulated industry which you need to think about your business model properly. Another example could be transport aggregation. We've seen Uber and Ola going through tremendous regulatory uncertainty in recent times. There could be, say, if you're starting a legal technology business, the law generally is a highly regulated business, and also fairly traditional in the way the profession is practiced. So any of these industries or any other regulated industry, you definitely need a lawyer from day one to just make sure, firstly, you can do what you're trying to do, and second is, if you can, how does your business, whether your specific business model is permitted, does it require to be tweaked to either be permissible or to reduce the regulatory risks involved. Having said that, there are other businesses where while there may not be as many regulations, there still is a certain amount of ambiguity in the regulatory environment. A classic example is Uber, which it is a fairly large global corporation now, operating across a number of countries for a fairly long time, and a fairly profitable business. Despite that, in multiple countries, it still continues to be embroiled in regulatory issues. Lately, India, but also Germany, Spain, many other cities where the service has been banned, and it continues even in its kind of original market, which is the United States, still continues to face tremendous amount of legal challenges or legal issues, lawsuits, things like that. So it is definitely important for one to be aware, for a promoter to be aware of regulatory issues that they're likely to face. Having said that, there are many other businesses in the online space, particularly where there's probably very, very little regulation, and you're free to go ahead. So just important to kind of get some quick clarity through maybe online search initially, and then if you think there's some regulatory clarity required, go to a lawyer. The fourth is intellectual property, and I will start that discussion firstly with the issue of choosing the right name for yourself, followed by choosing the right logos and taglines for yourself. A name having trademark issues or domain name problems is certainly a problematic issue, particularly if you're in the online space, where once you have established enough of a brand recall for your website and for your there's a footfall, there's an online footfall. It is definitely fairly damaging to the business if you were to have to choose change your name later on because of some trademark issues. Or for example, if a competing business which comes up and starts using a potentially confusing name, those are the kind of things you would like to avoid. And typically, the advice given is go with a fairly unique name which possibly does not mean anything, which is generic, which is almost arbitrary. The strongest trademark protection is available to names which typically do not mean anything, particularly do not have any correlation with the industry in which the business operates. And there are great examples all around us. You will see there's a trend among startups of choosing these kinds of unique names, particularly also because it is hard today to find the right domain names, particularly with the with a .com or other popular extensions. So the way to go about this is, firstly, of course, to do a proper internet search, to see if there are any kind of conflicting or even names which come close to the name that you're working with. And if there are, then you are better off getting a lawyer to at least do a trademark search to ensure that there is no conflicting trademark registered with the name already. Having said this, once you have finalized on the name which you are reasonably confident is not conflicting with anything, with any other name, the question whether you should trademark, when you should trademark the names does come up, and that's again a question which requires consideration because there's a cost attached to filing of a trademark. There's a government filing fee, there's a legal fee, and so most startups would ideally want to defer registering trademarks until as long as they can, and particularly until the post-investment stage. Now, most investors will anyway force you to compel you as part of the investment process to get your names trademarked, but you can potentially defer that decision until then, especially in cases where you have an online business. The reason being, and I'll give you a little background of or a little more perspective on what a trademark is. See, a trademark is primarily a right of use over a mark which is associated with your business. But trademark by itself does not give you the right to use a mark. The trademark, the right attaches to you the moment you start using the mark itself. So for example, if you were to start, you come up with a new name, you start using it, you register a domain name with that with the same name, you start doing business. The moment you started use, you already have a right over that mark. A trademark only serves, or a registered trademark with the trademark office only serves as evidence that you're actually the first user of the of that mark. And hence, if you're an online business, particularly, there is recorded proof that you are using, provided you actually are using the mark, and therefore you already have a right to it. So you don't. So even if you were to defer getting the trademark registered until, say, post-investment, that is usually okay. The other issue I want to talk about is considering your IP protection, and here, of course, I mean I'm moving beyond just trademarks. Other IP protection could be on particularly, which a lot of startups are interested in, is patents, which is patents on products and even algorithms for mobile apps and stuff like that. Now, one thing that you need to understand, particularly for those who are in an online or internet-enabled business, is that in fact, even before that, let me step back a little bit. There is no copyright, patent, trademark, or any other intellectual property protection that is available on a pure idea as such. An idea cannot be IP protected. It is the and what follows from there is that algorithms, in fact, software cannot be patented. Software can be copyrighted, yes, but it's a very weak protection because what copyright is a very specific kind of IP protection which is available only on the form or the expression, not the core not the substance, or not the core idea itself. So if you get a copyright on a software, a piece of code, the copyright is only available on the expression or the way the code or the way something is being coded. So if you were to code something in Java, get a copyright protection on it, and tomorrow code the same thing in a different language, your copyright protection doesn't mean anything at all. Now, patent, on the other side, is typically a much more stronger substantive protection. The problem with that, with patentability of software, is like that is currently not allowed in India. Now, having said that, people do find other ways of, so for example, if there is a software or hardware integration, that is where you can potentially patent that package. A lot of software companies do apply for patent protection nevertheless, and that is because there is a fair bit of one. It is they try to establish some kind of software hardware integration, or otherwise they try and or there's a hope that this law will actually change, because there's a fair bit of debate and lobbying going on the issue. And if that were to ever happen, some of these applications may go through. But as of today, for most startups, you really need to consider whether if you're in a software-enabled business, is the subject matter really patentable or not, and should you be spending time, money on that or not? Apart from software, of course, one other point which people need to keep in mind with regard to patenting, and particularly for product patents, is that any disclosure of any sort basically takes away your the opportunity to patent. There's one example of a client I was advising, which it was a new medical procedure with the use of certain specialized equipment which this doctor had invented. This unfortunately, in this case, the inventor disclosed or published certain articles on this new procedure in medical journals. And he also got a lot of critical acclaim, because of which he was invited to speak at seminars and stuff like that. But this disclosure amounts to, the moment the specifications of an invention are disclosed, it is no longer patentable. And so these kind of things are become very crucial. If you have to disclose your specifications to anybody, particularly say you have to disclose the specifications to a product design company or a manufacturing or contract manufacturing company, you should always do it pursuant to a very strong non-disclosure agreement or a confidentiality agreement that does ensure that you can still go ahead and patent the invention. The next point I want to discuss is about investment term sheets and investment documentation, and the concern being giving away too much in your angel round term sheets. Now, a lot of promoters consider when they're raising an investment round, that given that it's an angel round with not too much money being pumped into the business and not too much at dilution, they feel that they can do away with the requirement to have of having a lawyer representing them at the round, and they hope that they will spend on a lawyer probably much later at a larger investment round, which I feel is a mistake, because of one, that unfortunately, at least in India, as opposed to certain more established or startup funding markets like, say, the US, there is not so much of, or there's not too much of a distinction between an angel term sheet and a pre-Series A or a Series A term sheet. Investors tend to push through fairly comprehensive term sheets even at the angel rounds, and entrepreneurs need to be worried. Now, not all investors do this on purpose. Many a times, unfortunately, there's a lot of angel investment activity happening in the country right now, and a lot of investors are also first-time investors who are not completely familiar or aware of or educated about the kind of term sheets that should be used like an angel round as opposed to, say, a much later investment round. It's common practice to just pick up a late stage investment term sheet and throw it at the entrepreneurs for signatures, even at an early stage. Now, this can be actually counterproductive, of course, for the entrepreneurs, but also for the investors, because a term sheet not suited for an early stage can actually really hinder the business operations, can restrict the flexibility available to entrepreneurs, and can actually reduce the appeal of the business to late stage investors. The one reason why entrepreneurs should be particularly wary of the terms they sign in at the angel round is because the terms that you sign up to at an angel round and the subsequent terms that you will sign up at later investment rounds will always be more onerous than the terms you first signed. No investor is going to give you the liberty of actually toning down the terms of investment you've already agreed to in an early round. So that's something which one should be very wary of. Particularly, a couple of terms that you should pay particular attention to are your exit rights, or drag along. Sometimes investors have or ask for the right to be able to drag you out of your own business, which is, if they are making a sale to a third party, they should be able to drag you also and compel you to sell your stake as well. That's one term which is fairly important to understand the implications of and to negotiate. Another term to look at is your anti-dilution. which is in case there is a future round is like a round which is not price favorable to the existing investors, then the existing investors will actually be issued more shares to make up for the loss they are for make up for the dilution they are going through in the later round. So some of these clauses are are fairly nuanced, and it's great to have an advisor, either a legal advisor or another consultant who understands and has experience of doing these kind of terms, of these kind of investment rounds. Moving to the next point, having good terms of use and privacy policy for your website. Now, terms of use is basically, in simple words, a contract. It is a contract for your with your users for doing business. In certain businesses, particularly where you are an online business and you are acting as an intermediary, the intermediary never wants to take or assume liability of the vendors or the user. Take an example, say a Flipkart is merely a marketplace where it is allowing vendors to sell to users directly. Does it want to assume liability for a product which is defective? Not really. How do you make sure that the customer doesn't come chasing you, doesn't sue you in the consumer forum? Is by having a proper contract with the terms of use with the user and with the vendor, which allocates this liability contractually. Right. So your terms of use become fairly important based on depending upon the model that you are or the business that you are in. There are certain businesses where the liability is particularly very significant. For example, if you're an intermediary, for example, in a health services environment, where you could potentially be sued for liability for some wrong diagnosis or wrong advice, and the liability could be significant. These are the kind of businesses where you should be very concerned and particular about the contract you put in place. The other important policy, which is increasingly becoming fairly crucial which is fairly crucial for promoters to understand implications of, is the privacy policy. Now, by the way, if a business is collecting, actually, let me backtrack a little bit and explain what a privacy policy is. So, privacy policy is basically a policy which states the terms upon which a website will collect any information, any user information, and the terms on which it will use that information, whether it's going to disclose it to somebody, it is going to sell it to somebody, for example, advertisers. All this needs to go in the privacy policy. Now, the whole information collection and use is becoming a very significant issue. One great example of information which, or actually, I mean, these days, all online businesses, particularly which are providing free services, are particularly looking to monetize the data that they collect from users, right? And a lot of startups go to no ends in collecting data which, firstly, is none of their business, and then using it in ways which are not, which if were known to customers, they would never sign up for. So one classic example, and I don't know how many of you know, is that the flashlight application, actually, which you use on your mobile phone, actually collects your location data. It knows real time where you are at any point in time. None of their business, and has no correlation with the actual objective of the application or what objective it is trying to serve. Now, can it do that? Should it do that? That's a question which is being heavily debated the world over. But for promoters or startups, it's very important to understand the implications of collecting this kind of data and using it. At least in India, the data privacy laws are not very strong, but there are laws. And at the minimum, what you need to do, firstly, is to have a privacy policy. You cannot not have a privacy policy if you're collecting information. Second is, you should make disclosure of what kind of information you're collecting and exactly what use you're going to put it to. And the fourth is that you need to have a compliance officer, any employee or maybe the founders, and it's somebody responsible whose name and contact details are listed on the privacy policy, who can be contacted by users in case they have a privacy related concern. Right? A lot of startups don't understand, appreciate, or the implication of these things. And so far, there hasn't been any major issue in India either. But given the magnitude of the issue, the kind of misuse that is being that is currently happening with a lot of startups are really pushing the boundaries in terms of what they can do with information. There are bound to be mishaps and issues in the future, and the courts are not going to take this very lightly. And there is a law which clearly states what your responsibilities are. So any business where you are collecting very sensitive personal data, and sensitive personal data could be financial data, credit card details, name, address, etc. Of course, health apps need to be very particular because personal health related information is considered very critical by under the law. So personal data, if you're collecting, you have to be particularly very careful on how you use it. The next point is having great standard form contracts. Now, standard form contracts are, so basically, of course, any startup needs to enter into contracts. Terms of use and privacy policy are contracts which are online. But apart from that, you may need vendor contracts. Contracts with material suppliers if you are, say, an e-com business. Contracts with users, contracts with third parties like website developers. You need to have these contracts and particularly vetted by a lawyer from a liability perspective. Are you taking too much liability than you should? Who should be liable in the eventuality of a mishap or any? So all these all eventualities need to be firstly assessed and then need to be addressed in the contract. And then comes the point of having standard form contracts, which is that if you are going to enter into similar kinds of contracts with multiple parties, say a vendor contract, and you're in the business of you're an e-commerce player, you're bound to have hundreds of vendors at the back end. You don't need to reinvent the wheel every time. So you need to have a good quality standard form contract, or maybe 2 or 3, depending on the types or categories in which various vendors fall into, and use those standard form contracts. That's a good way of basically reducing your legal spend. The last point that I want to talk about is addressing important tax issues. And I don't pretend to be a tax advisor, having any great specialization in this field, but tax is something which a lot of startups of late have found themselves covered by a couple of issues which particularly a lot of startups today are facing. One is what is popularly known as the startup tax, which is an important issue for any startup which is raising an investment round. So the background to this is that if you are if you are basically getting into an investment round at a certain way, and the investor is putting in money at a certain valuation in the company, if that valuation is higher than the fair market value of the shares of the company, then there's a tax implication. Similarly, if the valuation of the company is at a discount to the fair market value of the shares, again there's a tax implication. If it is higher than the fair market value, then the tax implication is on the person who's benefiting from it, which is the company. If the shares are being issued at a discount to the fair market value, then the implication is on the person again who's benefiting, which is the investor in this case. Now, why this issue becomes comes up very commonly with startups is because, particularly through the last 1 year, many startups have been raising multiple rounds in very quick succession. So what happens is once you raise a first round, which sets the valuation of the shares at, say, for example, 100 rupees a share, that basically gives a benchmark, or sets a benchmark as to the fair valuation of the shares. Now, if your shares are fairly valued or deemed to be fairly valued at 100 rupees, and you in a month's time raise another investment round at a significantly higher valuation, say 200 rupees, and this is not very uncommon. It's been happening particularly in the kind of as the markets were heating up through the last 1 year. So if you raise another round at almost double the valuation, but in a month's time, the tax officer is obviously going to ask you what has changed so drastically in the last 1 month, which justifies a spurt in the valuation in such a short period of time. And therefore, his argument is going to be that the fair market value of the shares is still 100 rupees, which is the value of the last round, but you have made a gain of 100 rupees premium, right? And you're going to be taxed on that exact 100 rupees. So this is one key issue which startups need to bear in mind and consult their tax advisors or lawyers before they, particularly if they're getting into investment rounds in quick succession. The other issue which is becoming, which last year was a lot in news, was all e-com companies like Amazon, Flipkart, Snapdeal were having a number of service tax and sales tax issues across various states. And similarly, if you're a service provider, then there are a number of service tax implications which are important, and especially important. I mean, it's okay if you do not understand these issues through and through when you start out, when you're small, because you can fly under the radar for a little while you also get clarity on the issues. But once you have raised a certain investment, a sizable investment round, and you're doing substantial revenues, it is important to get to the bottom of some of these issues. Otherwise, you could find yourself in a situation where the penalties can be tremendous. So that's really all. Just a quick overview of some of the issues that one needs to consider while starting out. As I said very early on, the certain issues which are very important need to be dealt with right up front. Co-founders agreement is essential. Starting out the business as a company is something which is probably the second issue you need to be dealing with. But then there are certain issues like trademarks, tax issues, standard form contracts, which can probably wait for a little while, but these need to be kept in mind. Yeah, that's about it. Good luck with your ventures.
All right, thank you, Anirudh. But could you just explain this investment term sheet a little, angel round which you spoke about?
Sure. Yeah, happy to talk about term sheet. Certain of the very key terms of the term sheet in a little, not very, just very briefly. That's a subject which can take another 2 hours to kind of delve into. But typically, see, I mean, investment term sheet sets out the. So actually, just to give you a little bit of background, an investment term sheet is basically a summary document of the more comprehensive investment agreement which is to follow. And some of the key terms that investors that co-founders need to have clarity on when they are looking at their term sheet. As I mentioned earlier, your anti-dilution rights, drag along and tag along, and other exit rights that you have, reserve matters, are matters where the investors say these are the matters where you cannot do anything unless you get my affirmative vote on. So I have a veto over these kind of decisions, and which is fair to a certain extent. For example, there are issues where supposedly decisions regarding changing the very nature of your business, or issues regarding taking indebtedness, which is significant when looked at in perspective of the overall revenues of the company. Now, these kind of decisions, of course, the investor should have a say. But when the investor starts to tries to push down a 20-point reserve matter list at you, that really starts becoming more of micromanagement, which is where then you are literally, it is you, the promoter, who should be running the business, not the investor. And if you have to go to the investor for consent over every small decision, then it is going to be a great hindrance in your ability to effectively and efficiently run your business. So that's another point which you need to be which you need to consider fairly carefully and evaluate. Your non-compete is very important because typically investor is well within its right. It's fair to say that the promoter should not compete with the very business of the company he started with during while he's an employee of the company, but after, for a reasonable period of time, say a year or two, he should not enter into a similar kind of business. Now, what promoters need to be careful about is that the scope of what is a competing business should not be too broad, so as to basically say that, for example, if you are in an e-commerce business and you want to say that you will not compete with or you will not start any software business because an e-commerce business is a software business to begin with. That is overreaching, because then what will the promoter? What is the promoter then left to be able to do after the? I mean, there's very little that he can really do, and there is not much else that he knows. Assuming that that is his core capability. So what is the scope of the non-compete? What can you really do or not do after you've left the business is again something which is very, very important for a promoter to carefully negotiate. So these are some of the things which, I mean, a term sheet really requires a separate discussion altogether. But these are some of the key considerations which we have to deal with in advising promoters.
All right, Anirudh, thank you. Thank you for your time. And thank you all. If you have any doubts, please email or WhatsApp me so that we can get the doubts answered.
My
Thank
pleasure,
you.
Garima. Thank you for organizing this. Bye.
Bye.